Day, sir. Today we're going to tackle about the cybercrime laws in the Philippines. Republic Act number 10175, known as Cybercrime Prevention Act of 2012. The state recognized that the vital role of informations and communication industries such as content production, telecommunication, broadcasting, electronic commerce, and data processing in the nation's overall social and economic development. The state also recognized the importance of providing an environment conducive to the development, accelerations, and rational applications and exploitations of information and communication technology to attain free, easy, and intelligible access to exchange and or deliver of informations, and the need to protect and safeguard the integrity of computer and communication systems, networks, and databases, and the confidentiality, integrity, and availability of informations and data is stored therein from all forms of misuse, abuse, and illegal access by making punishable under the law such conduct and conducts. In this light, the state shall adopt sufficient power of effectively prevent and combat such offenses by facilitating their detections, investigations, and prosecution at both domestic and international levels, and by providing arrangement for fast and reliable international cooperations. Republic Act number 10175, known as Cybercrime Prevention Act of 2012, which completely addressed crimes committed against and by means of computer system on September 12, 2012. It includes penal substantive rules, procedural rules, and also rules on international cooperations. In 2019, the number of cybercrime incidents within the National Capital Region of the Philippines was highest for those who had been sent fraudulent SMS or text scam, amounting to approximately 2.7 million victims. Other cybercrimes committed in the country involve hacking, phishing, and cyberbullying. Among the crimes punishable under RA Republic Act 10175 are libel, cybersex, child pornography, and offenses against the confidentiality, integrity, and availability of the computer data and system, like legal access, legal interception, data interference, system interference, misuse of device, and etc. Cybercrime incident within the National Capital Region of the Philippines in 2019: SMS, text or fraud scam 2,739, hacking 257, phishing 58, cyberbullying or cyber libel 30, other 7.75, and have not been a victim 4,899. Acts cybercrime offenses. Number 1 is offenses against the confidentiality, integrity, and availability of computer data and system. Number 1 is illegal access. Ang illegal access is pag-access sa sistema sa isa ka computer without the right, no. So number 2 is illegal interception. Ang illegal interception is ang interception nga gihimo pinaagi sa technical pagpasabot nga walay katungod na bisan unsa nga dili publiko nga pagpasa sa data or computer ngadto gikan o sulod sa sistema sa computer, lakip na ang electromagnetic emission gikan sa computer sistema nga nagdala sa maong computer data. So number 3 is data interference. Pagpanghilabot sa data, no. Ang tinuyo o walay pagtagad nga pagbag-o, pagdaot, pagtangtang o pagkadaot sa datos sa computer or data sa computer computer, electronic nga dokumento o electronic data nga minsan nga walay tuo, laki pa nga pagpaila sa pagpasa sa mga viruses. And number 4 is system interference. Ang system interference ang tinuyo nga pag-usab o walay huno nga pagbag-o, pagpanghilabot sa lihok sa computer or computer network pinaagi sa pag-input, pagpadala, pagdaot, pagtangtang, pagkadaot, pag-usab, pagpugong dato sa computer or document electronic data minsan nga walay katungod or authority nga gikan sa authorized person nga lakip na pagpaila sa pagpasa sa mga viruses. 5 is misuse of devices, the use of production, sale, procurement, importation, distribution, or otherwise making available without the right. So, muna siya ang mga sayop nga paggamit sa devices, no? Ang paggamit sa production niya, pagbaligya, pagpamalit, importation, or etc. Letter A and letter I sa letter A, number 1 sa letter A is device including, so, mga program bitaw sa cellphone, like, ini nga cellphone yung mga program diri, so, yung siyang gigamit para magbuhat bitaw sa mga dili maayong mga app. Ang letter, number 2 sa letter A is computer password access code, so, ang kanang the whole part of system, kanang sistema, ang sulod gyapon na ni sa kuan nga, anang mga computer password, imo siyang gikuan bitaw, imo siyang gigamit para mo buhat sa mga dili maayo nga mga butang. Letter B, the possession of an item referred to in paragraphs 5 above with the intended use and so muna siya ang pag sa butang nga gitumong pag giapis kun muna siyang kanang naka-intent nga para kanang pagbuhat kanang naka-intent nga imo na siyang kuanon kay para mabuhat ka og isa ka dili maayo nga butang. So number 6 is cyber squatting. So ang cyber squatting is ang pag-angkon sa usa ka ngalan sa ibabaw sa internet sa dili maayong pagtuo aron makaganan siya, makapanghilas ug makaguba sa reputation. So like for example, no, letter A is mga pagsama sa makaibong sumama sa usa ka. So cyber squatting ha, to make the kanang para ma-short ba. So ang cyber squatting lang ha, formula sa mga subten is more siya kanang bitawong sa Facebook kanang mga posters, so gigamit nimo ang isa ka silbi ako gigamit akong pangalan ako, apil akong mga pictures para madaot akong reputation sa akong mga enemies bitaw, mga basher bitaw kunuhay nga gigamit akong noun ang akong mga pictures nga mga kuan dahil akong name tapos makig-away sa lain ng mga tao, so gidaot niya akong reputation bitaw, so muna siya ang cyber squatting. So ang 2 is computer-related offenses. Number 1 is computer-related forgery. The input, alteration, or deletions of the computer data without the right, resulting in authentic data with the intent that be considered or acted upon for illegal purposes, and if it were authentic regardless whether or not data is directly readable and intelligible. So ang pasabot niya is ang pag-input or pagbag-o, pagtangtang sa bisag unsa nga mga data sa computer no nga wala kay katungod. So letter B is the act of knowingly using computer data which is the product of computer-related forgery as defined herein for the purposes of perpetuating a fraudulent or dishonest design. So kanang bitang kanang nanakay knowledge no nga paggamit na pagbuhat na nga mga butang like pagpameke naana jud bitaw kay kuan naana kay kuan ba intent na kay hunahuna nga insakto nga ang imong gibuhat is sayop. So number 2 is computer related fraud. Ang computer-related fraud or pandarayan na nauugnay sa computer, hindi ito sa input, pagbag or pagtanggal or input attenuation, deletion of computer data or kanang program or interference in the functioning of a computer system causing damage thereby with a fraudulent intent. So, pag himasok mo pag ng isang computer na naging sanhi, muy sinugdanan nga na guban, pinsali bitaw ngayon nga. So, ang number 3 is computer-related identity thief. So, ang computer-related identity thief is pagnanakaw from the word theft. Pagnanakaw, related siya sa computer nga nakaugnay sa computer. Ang sinadyang pagkuha, paggamit sa maling paggamit, paglipat ng pagmamay-arin sa pagbabago, pagtanggal ng pagtukoy ng informasyon pagmamay-arin ng iba natural man or veridikal ng iba natural nang walang karapatan sa kondisyon na kung walang pinsalang na idulot na ang arusang impossible ay dapat na isang so imo siyang gikuan theft, imo gikawat mga gikawat ninyo no. So
good day, sir. This is the continuation of our discussion, Chapter 5, Cybercrime Laws in the Philippines. We all know that every crime committed has a penalties, but every penalties depends on the crime that we committed. So my topic for today is all about penalties. Any person found guilty of any of the punishable acts enumerated below. A. Offenses against confidentiality, integrity, and availability of computer data and system. Computer-related offenses shall be punished with imprisonment of prison mayor or a fine of at least 200,000 pesos up to a maximum amount commensurate to the damage incurred or both. B. In person found guilty of the punishable act under Section 4A.5. Offenses against the confidentiality, integrity, and availability of computer data and systems. 5. Misuse of devices shall be punished with imprisonment of prison mayor or a fine of not more than 500,000 pesos or both. If punishable acts in Section 4A are committed against critical infrastructure, the penalty of reclusion temporal or a fine of at least 500,000 pesos up to maximum amount commensurate to the damage incurred or both shall be imposed. C. Any person found guilty of any of the punishable acts enumerated in Section 4C.1. Content-related offenses. 1 is cybersex. Shall be punished with imprisonment of prison mayor or a fine of at least 200,000 pesos but not exceeding 1 million pesos or both. D. Any person found guilty of any of the punishable acts enumerated in Section 4C.2. C. Content-related offenses. Number 2. Child pornography. Child pornography shall be punished with the penalties as enumerated in Republic Act No. 9775 or the Anti-Child Pornography Act or of 2009, provided that the penalty to be imposed shall be 1 degree higher than the provided for any Republic Act No. 9775 if committed through a computer system. E. Any person found guilty of any of the punishable acts enumerated in Section 4C.3, C. Content-related offenses, and 3. Unsolicited commercial communication shall be punished with imprisonment of arresto mayor or a fine of at least 50,000 pesos but not exceeding 250,000 pesos or both. F. Any person found guilty of any of the punishable acts enumerated in Section 5, Section 5, other offenses, shall be punished with imprisonment 1 degree lower than that of prescribed penalty for the offense or a fine of at least 100,000 pesos but not exceeding 500,000 pesos or both. Corporative liability. When any of the punishable acts herein defined are knowingly committed on behalf of or for the benefit of a juridical person by a natural person acting either individually or as part of an organ of the juridical person who has a leading position within based on A power representation of the juridical person provided the act of committed falls within the scope of such authority. B. An authority to take decisions on behalf of the juridical person provided that the act committed falls within the scope of such authority, or C. An authority to exercise control within the juridical person. The juridical person shall be held liable for a fine equivalent to at least double the fines imposable in Section 7 liability under other laws. A prosecution under this act shall be without prejudice to any liability for a violation of any provision of the revised penal code. As amended or special laws up to a maximum of 10 million pesos if the commission of any of the punishable acts herein defined was made possible due to the lack of supervision or control by a natural person referred to and described in the preceding paragraph, for the benefit of the juridical person by a natural person acting and under its authority. The juridical person shall be held liable for a fine equivalent to at least double the fines imposable in Section 7 up to a maximum of 5 million pesos. The by a natural person acting and under its authority. The juridical person shall be held liable for a fine equivalent to at least double the fines imposable in Section 7 up to a maximum of 5 million pesos. The liability imposed on juridical person shall be without prejudice to the criminal liability of the natural person who has committed the offense. Corporate liability, also referred to as a liability of legal persons, determines that extent to which a company as a legal person can be held liable for the acts and omissions of the natural persons it employs, and in some legal system for those of other associates and business partners. Enforcement and implementation. Law enforcement authorities. The National Bureau of Investigation (NBI) and the Philippines National Police or PNP shall be responsible for the efficient and effective law enforcement of the provision of this act. The NBI and the PNP shall organize cybercrime unit or center manned by special investigators to exclusively handle cases involving violations of this act. Duties of law enforcement authorities. To ensure that the technical nature of cybercrime and its provision is given focus on considering the procedures involved for international cooperation. Law enforcement authorities, specifically the computer or technology crime divisions or units responsible for the investigation of cybercrimes, are required to submit timely and regularly reports including pre-operations, post-operations and investigations results, and such other documents as may be required to the Department of Justice or DOJ for review and monitoring. Cybercrime law identifies standards of acceptable behavior for information and communication technology, or ICT users, establishes socio-legal sanctions for cybercrime, protects ICT users in general, and mitigates or prevents harm to people, data systems, services, and infrastructures, in particular protects human. Real-time collection of traffic data. Law enforcement authorities with due cause shall be authorized to collect or record by technical or electronic means traffic data in real time associated with specified communications transmitted by means of a computer system. Traffic data refer only to the communications origin, destinations, route, time, date, size, duration, or time underlying service, but not content nor identities. All other data to be collected or seized or disclosed will require a court warrant. Service providers are required to cooperate and assist law enforcement authorities in collection or recording of the above stated information. The court warrant required under the sections shall only be issued or granted upon written application and the examination under oath of permission of the applicant and the witnesses he may produce and the showing 1. That there are reasonable grounds to believe that any of the crimes enumerated herein above has been committed or being committed or is about to be committed. 2. That there are reasonable grounds to believe that evidence that will be obtained is essential to the conviction of any person for or to the solution of or the prevention of any such crimes. And 3. That there are no other means readily available or obtaining such evidence. Preservation of computer data. The integrity of traffic data or subscriber information relating to communication services provided by a service provider shall be preserved for a minimum period of 6 months from the date of the transaction. Content that shall be similarly preserved for 6 months from the date of receipt of the order from law enforcement authorities requiring its preservation. Data preservation is the act of conserving and maintaining both the safety and integrity of data preservation. It's done through formal activities that are governed by policies, regulations, and strategies directed towards protecting and prolonging the existence and authenticity of data and its metadata. Disclosure of computer data. Law enforcement authorities, upon securing a court warrant, shall issue an order requiring any person or service provider to disclose or submit subscribers' information, traffic data, or relevant data in its possessions or control within 72 hours from receipt of the order in relation to a valid complaint officially docketed and assigned for investigation and
search and seizure and examination of computer data. Where a search and seizure warrant is properly issued, the law enforcement authority shall likewise have the following power and duties. Number 1, to secure a computer system or a computer data storage medium. So kung isa sir is i-secure ang computer system o data na na-store sa computer. Number 2, to make and retain a copy of those computer data secured. So kinahanglan o ganang katong mga data is nato sila mga copy nga naka-secure daan. To maintain the integrity of the relevant stored computer data para dili siya mamulik sa lain nga mga systems. Number 4, to conduct forensic analysis or examination of the computer data storage in medium. So kinahanglan siya og ganang conduct og forensic nga examination sa atong computer o data nga na-seize o na-search. To render the inaccessible or remove those computer data in the access of computer or computer communications network. So katong mga data, so seize ato, so i-remove to sa dito sa computer nga na-seize ug apil nato yung mga data. The law enforcement authorities may order any person who has knowledge and functioning of the computer system and the measures to protect and preserve the computer data therein, to provide as reasonable the necessary information to enable the undertaking of the search and seizure and examination. So ang law enforcement authorities, so kinahanglan sila og itong mga experts sa about computer systems para dili ma-save sayop ang pagkuha sa mga data. So the law enforcement authorities may request for an extension of time to complete examination of the computer data storage medium and to make return therein, but in no case for a period longer than 30 days from date of approval by the court. So ma-request ang law enforcement sa extension para ma-collect to mga data storage. So in case period longer than 30 days, so 30 days ang extension, pero kinahanglan nag-approval sa court. Custody of computer data. All computer data including content and traffic data examined under proper warrant shall within 48 hours after the expiration of the period fixed therein be deposited with the court in sealed package and shall be accompanied by an affidavit of the law enforcement authority executing stating dates and times covered by the examination in the law enforcement authority who may access the deposit among the relevant data. So all computer data including traffic data is na-examine sa mga law enforcement with a with a warrant within 48 hours dapat siya ma-deposit accompanied by the affidavit from the law enforcement authority. So dapat po dito kung kanusa siya sa ang date nga pag search and seizure. The law enforcement authority shall also certify that no duplicates or copies of the whole or any thereof have been made, or if made, that such duplicates or copies included the package deposited with the court. So dapat ang law enforcement secure nila nga walay lain copies or duplicate nga data, or kung naaman nga ni, so dapat ma-appeal siya dito sa package. The package so deposited shall not be opened or the recordings played or used in evidence or then contents revealed except upon the order of the court, which shall not be granted except upon motion, with due notice and opportunity to be heard and to the person or persons whose conversation or communication have been recorded. So ang package nga nagibutangan sa data, so dili ito siya pwede ma-open antod sa dili tugutan sa court. Destruction of computer data. Upon expiration of the periods as provided in Section 13 and 15, service providers and law enforcement authorities, as the case may be, shall immediately and completely destroy the computer data subject to preservation and examination. So, ano siya is, muna siya, di ba lang pag-distract or pagguba sa itong data nga na-confiscate or na-seize from the search and seizure. So after ay gubaon ni siya after mahuman ang preservation and examination. Exclusionary rule. Any evidence procured without a valid warrant or beyond the authority of the same shall be inadmissible for any proceeding before any court or tribunal. So itong mga datas or evidence from computers na nakuha, if dili siya legal ang pag search and seizure ato, so inadmissible siya o dili siya dawaton sa court. Restricting of blocking access to computer data. When the computer data is prima facie found to be in violation of the Provisions Act, the judicial issue the order of restrict or block the access of sa computer data. So if bisag wala siya walay power of the warrant, so if kato siya nga data is illegal o nakita gid nga dili maayo, so i-block ko siya nga computer data. Non-compliance. Failure to comply with the provision of Chapter 5 thereof, especially the orders from law enforcement authorities, shall be punished as a violation of Presidential Decree number 1829 with the imprisonment of prison correctional in the maximum period of fine 100,000 pesos or both for each and every non-compliance with an order issued by law enforcement authorities. So failure to compliance the seized data or information from computer, so makasuhan sila under the Presidential Decree number 1829, so with the imprisonment of prison correctional maximum period and a fine of 100,000 pesos for each and every non-compliance with an order by law enforcement. So 100,000 pesos sa kada dili ma-issue or dili ma-comply nga datas nga na-search. Jurisdiction. The original trial court shall have jurisdiction over any violation or provision of this act, including the violation committed by a Filipino national regardless of the place or commission. Jurisdiction shall lie if any of the elements was committed within the Philippines or committed with the use of computer system, wholly or partially situated in the court country, or when such commission any damage is caused to a natural or juridical person who at the time of offense was committed was in the Philippines. So ang jurisdiction ng kaso is sa Regional Trial Court. So if nakabuhat ka ganang crimes about sa computer data in the Philippines, so diri ka kasuhan. There shall be designated special cybercrime courts manned by specially trained judges and handled by cybercrime cases. So there is a cybercrime courts for the any crime that related to the cyberspace or computers. So napod sila trained judges nga mo-handle sa mga cybercrime cases. General principles relating to international cooperation. All relevant international instruments or international cooperation in criminal matters arrangements agreed on the basis of uniform or reciprocal legislation in domestic laws to the widest extent possible for the purposes of investigations or proceedings concerning criminal offenses related to the computer systems and data, or for the collection of evidence, electronic form of criminal offense shall be given full force and effect. So, na sila international cooperation sa every cybercrime. So, naitabo sa computers, including data. So, na mga international cooperation nga mag-investigate o mag-gather sa data nga naka-uniform na siya daan. And the laws must be full force in implementing so that it will be effective. Department of Justice. There is hereby created an Office of Cybercrime within the DOJ designated as the central authority in all matters related to international mutual assistance and extradition. So, ang DOJ, so, nag-create sila ng Cybercrime Office for the designated only for the central authority in all matters. So, naging mas sila office for the cybercrime lang. Cybercrime Investigation and Coordinating Center, an interagency body of the known as the Cybercrime Investigation and Coordinating Center or CICC, under the administrative supervision of the Office of the President for the policy coordination among concerned agencies and for the formulation and enforcement of the National Cybersecurity Plan. So, CICC or the Cybercrime Investigation and Coordinating Center. So, para nisa sa crime related in cyberspace or computer nga tanan na hitabo nga crime sulod sa computer. So, powers and functions to formulate National Cybersecurity Plan and extend the commission of the cybercrime offenses through the Computer Emergency Response Team. Number 2, to coordinate the preparation of the appropriate and effective measures to prevent and suppress cybercrime activities as provided for in this Act. To monitor the cybercrime cases being banded, participating in the law enforcement and prosecution agencies. So, one is ilang functions is to monitor the cybercrime cases that being banned by the law enforcement. So dapat po, ilang purpose po is kanang naslay coordination sa lain-laing mga datas or mga computer cyber datas to form international cybersecurity plan extend. So dapat naslay mga plano for the cyber crimes. Number 4, to facilitate international cooperation, intelligence, investigation, training, and capacity building related to cybercrime prevention, suppression, and prosecution. So mag-facilitate sila o ng international cooperation para sa mag-investigate, training, capacity related to cybercrime. So nasa like training sa silang personnel para sa cybercrime prevention. To coordinate the support of the participation of the business sector, local government units, and non-government organizations, cybercrime prevention programs, and other related projects. So, para ilang masuportahan itong mga nasa government and non-government nga datas, computer datas, para dili siya ma-appeal sa mga cybercrime. To recommend the enactment of appropriate laws, assurance and measures and policies. So, dapat kanisla is munis lang magpatuman sa mga balaod in relation sa cybercrime. To call upon the government agency to render the assistance of the accomplishment of the CICC's related tasks and functions. To perform all other matters related to cybercrime prevention and suppression, including capacity building and such other functions and duties as may necessary for the proper implementation of this act. So sila po ang magtanaw sa proper implementation sa cybercrime law. So sa mga acts nga kinahanglan nga kanang sakto ang ipag-implement sa balaod. So that's all, sir. Thank you.